Hi, it's me, Fatima. Thank you for tuning in. I want to share this very important information with you. This is coming from the state of California, and in all states they do have this. It's titled under a different, probably title or a family code or family law number, whatever. But from the state of California, we're going to talk about the procedures for child support case registry form. This particular form is used by both parties before it goes to the clerk. And when it goes to the clerk, it goes to the Department of Social Services, which is, under the Department of Health and Human Services, the state of California. And then in turn, it's electronically filed for the to the nationwide database for child support. Now, this form is supposed to be signed under penalty and perjury from the judicial officer and child support agency that everything is and the information is true and correct in order for them to intercept your tax return, your wage garnishments, your bank levies, and any other monies that you've earned or that's owed to you. So I suggest that you demand a copy of the FL 191 if you're in the state of California, which is the family law form. You have every right to have a copy of it, and I'm going to explain to you or read to you in this information so that you can be better equipped. Now, you can find this form online. You can either go to the court's website, which is courts.ca.gov, or you can search online for California Rules of Court 5.330, and then also FL 191. FL stands for family law. Okay? So, under Rule 5.330, Procedures for Child Support Case Registry Form, the purpose in this rule provides guidance to court clerks in processing the child support case registry form FL 191. And it's highlight there. It's right here where I'm reading, okay? It's effective as of January 1st, 2007, and it was previously amended effective January 1st, 2003. Okay, the application here under B, it states the rule applies to any action or proceeding in which there is an order for child support or family support, except for cases in which the local child support agency provides support enforcement services under F Family Code Section 17400. Okay, now, well, there's not a child support order. They can't do an order. But, however, if there's a default judgment, that becomes an order. If there's a stipulation amongst the party, that becomes an order. If you do not contest the recommendation, that becomes an order. You have 10 days to contest it, and then an additional 10 days before it goes to the nationwide database. Now, it says here, this rule does not apply to cases. I'm reading right here. Okay. This rule does not apply to cases in which the local child support agency provides support enforcement services under the Family Code Section 17400. Now, this 17400 applies to welfare cases. Okay. So, right here, it says requirement that form be filed. Okay, maybe I'm not reading it right. But anyways, it says the court must. You see that word here? It says must. The court must require that a child support case registry form, FL 191, completed by one of the parties be filed each time an initial court order for child support or family support or a modification of a court order for child support or family support is filed with the court. Okay, so each time you file a modification, this particular form has to be completed, has to be filed. Okay, and some of us, like myself, I didn't know this. A party attempting to file an initial judgment, right here. Excuse me, sorry. It says a party a party attempting to file initial judgment or order for child support or family support, or a modification of an order for child support or family support without a completed child support case registry form, FL 191, must be given a blank form to complete. The form must be accepted if legibly handwritten or in ink or typed. No filing fees may be charged for filing this form. Okay, and that was amended effective January 1st, 2007. Okay, and it says here, under distribution of the form, copies of the Child Support Case Registry Form FL 191 must be made available by the Clerk's Office and the Family Law Facilitator's Office to the parties without cost. A blank copy of the Child Support Case Registry Form FL 191 must be sent with a notice of entry of judgment to the party who did not submit the judgment or order. So before they submit this over to the nationwide database or to the Department of Social Services, then you're supposed to receive a copy of this form, FL 191, and the alleged, I always say alleged because they don't do things right here in my county, entry of judgment. And oftentimes here in Sacramento, they don't have entry of judgments. They have minute orders and order after hearings, which is not an entry of judgment form. Okay? We're going to skip item E. We're going to go down to the F right here. Clerk handling of form. The completed child support registry form, FL 191, must not be stored in the court's file. It should be date and time stamped when received and stored in an area to which the public does not have access at least once per month. All forms received must be mailed to the California, where? To the California Department of Social Services. So when it goes to the Department of Social Services under the Title 4D program, it in turn is sent over to the State Disbursement Unit, which is State of California. You have the Human Services. Then it is imputed into the nationwide database, and that's how they do your wage garnishments, your tax offsets or interceptions, your bank levies, driver's license suspension, and so on and so forth. So that form needs to be completed before all this has been, taken action against you. If it's not completed, they violate your due process rights and your opportunity to be heard. So, letter G, storage of confidential information. Provided that all information is kept confidential, the court may keep either a copy of the form or the information provided on the form in an electronic format. Okay? And let's go over to the form, FL 194. And you can find it in the court's website, or you can search online, FL 191. Okay? You see here, child support case registry form, mother, father. They don't say custodial, non-custodial parent. Here it says this form will not be placed in the court file. It will be maintained in a confidential file with the state of California. Okay? There you go. So let's scroll down to the instructional information sheet. It says here, let's see. It says both parents must complete a child support case registry form. The information on this form will be included in a national database. You hear me? You see that? Both parents must complete a child support case registry form. The information on this form will be included in a national database. It says that, amongst other things, is used to locate absent parents. When you file a court order, you must deliver a completed form to the court clerk along with your court order. If you did not file a court order, you must deliver a completed form to the clerk court within 10 days, okay, of the date you receive a copy of your court order. If any other information you provided on this form changes, you must complete a new form and deliver it to the court clerk within 10 days of the change. The address of the court clerk is the same as the one shown for the Superior Court on your order. So basically, when you contest the recommendation of the commissioners for child support, their recommendation for child support, you have 10 days to contest it. And then you have an additional 10 days, which is a total of 20 days, before to contest it before it goes to the child support registry. Now, if you do agree to it, that's why you have to complete that form, and it has to be signed or stamped rather by the judicial officer, which is the commissioner. Then it goes after let me back up. Once the form is completed, it goes to the court clerk along with your alleged court order. Then it's signed by the judicial officer and stamped. And then from there, is mailed or electronically submitted to the Department of Social Services, the state of California. A copy is sent to the child support agency, the local agency. And then in turn, it is imputed through the state disbursement unit through the National Child Support Database. Okay? So, lastly, I wanted to show you that, and like I said, you get this form online as well. Right here, it's very important that you know this. Let's see here. I'll get my phone going good. And I do apologize because my computer has been compromised. I mean, my spell check doesn't work. Everything I into my type is all garbled, missing characters. And so, they got me again. So I'm getting on another computer. Hopefully soon so I can get back in motion. But anyways, here it says the local child support agency is required, you see here, required under Section 466A13 of the Social Security Act, which is 42 U.S.C. 666, to place in the records pertaining child support the Social Security number of any individual who is subject to a divorce decree, support order, or paternity determination or acknowledgement. This information is mandatory and will be kept on file at the local child support agency. Okay, that's right there. Come on, California. So I suggest you get on the ball, get this rolling, demand a copy of that 191, and then I would file a motion and to file something to the effect of, well, I don't want to say right now, but basically get in there, get a copy of this 191 form, because this has to be on file for them to intercept any garnishments. And then if they do any garnishments on you or interceptions, you have to have an opportunity to be heard. And you have to be noticed prior to any interceptions. So until next time, you guys, stay strong, stay encouraged, and be informed.